Welcome back to Winning Isn't Easy. Mutual of Omaha ignores federal safety regulations in denying a commercial truck driver's claim because of post-traumatic stress disorder. I've talked about how Mutual of Omaha tightly applies its policy terms, tightly requires objective proof, and how Mutual of Omaha world is kind of black and white. Now, you would think that black and white would be pretty clear in a case involving a commercial truck driving situation, but of course, not so much. We all know that commercial truck driving can be dangerous. Drivers are required to follow both federal regulations and company safety standards. That didn't deter Mutual of Omaha in this particular case. And I'm going to tell you the story of Larry Whetstone, who worked as a long-distance commercial driver for 7 years. A bus crashed into his 8-wheeler tractor trailer while exiting a turnpike, and there was some significant injuries, but he also developed post-traumatic stress disorder. He had severe mental problems, including anxiety, depression, insomnia, irritability, fear of driving his tractor trailer. Obviously, that's predictable, and one would expect given the severity of the accident and injuries. He sought the care of 3 doctors, all of whom opined he could not return to commercial driving in his medical condition. He applied for his long-term disability benefits, and United of Omaha denied his claim. Now, because Mutual of Omaha tightly interprets its plans, terms, and definitions, they always, in my view, rely on the requirement of objective medical evidence, or flip it around and rely on the subjective medical provisions that limit the payment of benefits. And I think one of the keys that's important in a subjective medical condition claim is not only physical problems, but psychiatric problems. So, for example, you might have a herniated disc that you sustained in an accident, you undergo surgery, the operative diagnostic studies are normal, but you still have pain. If there's a subjective medical condition limitation in the policy, the carrier is going to say, well, wait a second, this back pain, this muscle spasm, this stiffness, they're all subjective conditions, and the benefits are limited to just 2 years. And by the way, we're going to apply the mental nervous condition limitations if you're depressed because of your back condition and the pain that we won't pay on. So they use the whipsaw of the subjective complaint or the mental nervous limitations. And that's exactly the whipsaw that happened in Mr. Whetstone's case. So there are many psychiatric claims for anxiety, depression, and post-traumatic stress. They're all based on self-reported symptoms. And disability carriers and policies will generally pay for mental impairments recognized by the International Classification of Diseases, or the DSM manual of mental impairments. But mental impairments are generally limited to just 2 years of benefits, and they want a specific type of impairment. Now, obviously, in this case with Mr. Whetstone, they're looking for a reason to deny his claim. So they had his medical records reviewed by a psychologist who opined that even though the totality of the documentation supported his claim of emotional distress after the motor vehicle accident, there was no compelling evidence to support the presence of functional impairment, their favorite gobbledygook denial terms. So the liar for hire peer review determined that Whetstone's stated inability to drive a motor vehicle was a product of his own self-imposed avoidance rather than a true psychiatric disorder. And this opinion was based on the fact that Whetstone drove to and from his medical appointments in his personal vehicle. Now, when I go out of my office today and go home, I'm probably going to pass an 18-wheel tractor trailer. And I think there's probably a big difference between the size of that big ass truck and my vehicle. So obviously that's kind of ridiculous. The liar for hire peer review doctor opined that if Whetstone was functionally impaired, he'd also have problems with grooming, hygiene, suicidal ideation, poor impulse control, homicidal ideations, paranoia, psychosis, delusional thinking, disorganized thought processing, aggressive and hostile ideations, and excessively withdrawn behavior. Now, that's somewhat contradictory, but it's also something that I see a lot of. If you were so disabled, you should be suicidal or homicidal or da 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 da. That's not the standard of disability. The disability standard is generally an inability to do your own occupation or any occupation, not whether or not you're suicidal or homicidal. So, notwithstanding that opinion, the liar for hire doctor agreed that there was a diagnosis of an adjustment disorder with mixed anxiety and depressed mood, which of course allowed them potentially to argue that he was benefits were limited to just 2 years under the mental nervous condition. But what did United of Omaha do? Well, they rejected those subjective complaints, ignoring the fact there was a psychiatric diagnosis predicated on his self-reported symptoms. Now, that's how a diagnosis is made under the International Classification of Diseases, or the DSM manual. So the fact that they rejected his subjective complaints is like stupid, because that's how the diagnosis is made. But that's some of the games that disability carriers play. So this case gets better because the Department of Labor has regulations governing physical qualifications of commercial drivers. So, they're narrowly interpreting the plan terms. They are requiring proof that's not necessarily required. They're cherry picking the medical records. They have a liar for hire doctor who, quite frankly, renders a silly opinion. And now they're confronted with the Department of Labor's regulations, because this could impact his ability to be a truck driver. But not to be deterred and still looking for a reason to deny the claim, they say, okay, we're going to ignore 49 CFR 319.41, which are the regulations for commercial truck drivers. These regulations disqualify drivers who possess, in quotes, any mental, nervous, organic, or functional disease or psychiatric disorder that would likely interfere with their ability to drive a commercial motor vehicle safely. So, of course, United of Omaha gave the thumb, if you will, to those regulations on the basis that if he could drive his personal vehicle, he ought to be able to drive that commercial truck, and he could safely drive that commercial vehicle such that it wasn't a violation of the federal rules and regulations. Ultimately, of course, this case ends up in front of a federal judge, and the judge in Whetstone versus United of Omaha, which is an Ohio case, found that this denial was arbitrary and capricious because there was no substantial basis in the medical records to support the conclusion that he could perform the duties of his job. The judge said, look, you, United of Omaha, have overlooked and outright mischaracterized several parts of the record that supported the claim. You improperly dismissed his self-reported symptoms and the opinions of the treating mental health providers without even having one of your liar for hire providers examine him. And of course, you failed to consider the federal safety regulations. The judge said, look, these oversights were inexcusable given the fact that United of Omaha failed to consider that portion of the regulations that physically disqualified him if he had a mental, nervous, organic, or functional disease or psychiatric disorder likely to interfere with the ability to drive a commercial motor vehicle safely. Now, the court noted that a commercial truck driver who at any moment could suffer a post-traumatic stress-related fear response would be required to immediately pull off the side of the road or react. And they could react in a fashion that endangered not only them, but others. And Whetstone had reported having to do this numerous times because of his post-traumatic stress disorder issues. And the court found that that fit into the language of the regulation. The lack of psychosocial symptoms, being homicidal, suicidal, et cetera, cited by the liar for hire peer review doctors, were in the judge's opinion irrelevant to determining whether or not he could perform the material duties of his occupation and do so pursuant to the regulations. Fortunately, the judge saw through all of these created reasons that United of Omaha used to justify the claims denial and awarded his benefits. This case, I think, gives you a clue as to how United of Omaha and disability carriers are always searching for a reason to deny or terminate benefits. Fortunately, the judge saw through this. I hope you've enjoyed this week's episode of Winning Isn't Easy. Please like our page, leave a review, share it with your friends, and subscribe. I hope you tune in next week for another insightful episode of Winning Isn't Easy. Thanks.